So this is the panel on international economic law in times of crisis. I think we have been talking about international economic law in times of crisis for the past 3 days. And I think some of the items, don't worry about it, come on in, sit up front, don't go too far back so we can see each other. And we have all seen the tools that are being used, the tools that we have in international economic law or that have been created to deal with the times that we live in. I'm going to briefly introduce our speakers in the order in which they have actually decided to go, and I think it makes sense. We start with Professor Frank Garcia, who is Professor of Law and Dean's Distinguished Scholar at Boston College of Law. A Fulbright scholar, he has taught and lectured widely on globalization and international economic law in Europe, South America, and the Asia Pacific region. He's author of many works, but among other volumes, Consent and Trade, Trading Freely in the Global Market in 2019, and Global Justice and International Economic Law, Three Takes, both published by the Cambridge University Press. He has also published a lot of other things. I'm going to be short in terms of my introduction of our panelists. After Frank, we have Riccardo Vecellio Segate from the University of Dundee. I think you're also a research associate at the Alan Turing.
I'm actually only there now.
You're only at Alan Turing.
Yes,
okay,
the affiliation
because of the program
is
is wrong.
yeah.
Okay, a research associate at the Alan Turing Institute. Is an international legal scholar, technology regulator, and policy advisor specialized in complex law and technology and bioethics policies and transnational IP disputes with a focus on the EU, the UK, China, India, Japan, and the Gulf region. After, I think, Riccardo, we are going to go to Sylvia Chen, who is an independent trade policy and regulatory advisor and founded Egmont Trade Consulting. Their services include advising international business on diverse trade issues, including compliance with the US sanctions and export control regulations, as well as evaluating supply chain vulnerabilities. In 2019-2020, she was one of the Robert Bosch Foundation Fellowship recipients, for which she examined the transatlantic dimension of China trade matters while working in the German Ministry of Economics and Energy at Bosch. After Sylvia, we are going to hear from Tony VanDuzer from the University of Ottawa. Tony is a professor and previously held the Hyman Soloway Chair in Business and Trade Law in the Common Law section of the Faculty of Law at the University of Ottawa, as well as the adjunct research professor at the Carleton University's Norman Paterson School of International Affairs. His most recent book is an interdisciplinary study of investment policy, co-edited with Professor Patrick LeBlanc, Promoting and Managing International Investment Towards an Integrated Policy Approach. And last, but certainly not least, we have Rodrigo Polanco from the World Trade Institute, who is academic coordinator of WTO's Advanced Master Program. Rodrigo is a senior lecturer, researcher, and academic coordinator at the WTI at the University of Bern and a legal advisor for Spanish and Portuguese-speaking jurisdictions at the Swiss Institute of Comparative Law. In addition, he lectures at the University of Luzern and a visiting professor at the University of Chile, and also an editorial board of Journal of International Economic Law. So amazing group, and some of these are old friends that I haven't seen for decades. I think Frank I haven't seen for decades, and Tony as well. So thank you, SIEL. Thank you all for joining us. I'm going to turn to Frank, who's going to provide, I think, the most broadest framework, and then we will proceed in a sort of a more granular fashion, right, Frank?
Okay, thank you so much, Padideh. Thank you all for coming. So the title of my talk is Reconceptualizing Global Commerce in a Time of Crisis. And the subtitle is, What can the 18th century teach us about where we went wrong? Gives you some idea of what I'm engaged in. This is a larger project in which I'm trying to look at the roots of the current global framework to try to understand what the next iteration should be. So it is a sort of rethinking the system in a time of crisis, but by going back to the foundations and saying what went wrong, what was the promise, and what's been the disappointment. So Adam Smith figures pretty largely in this. Immanuel Kant figures largely in this. And I've already can see that this early morning is not the time to go into German philosophy. And I don't even want to mention Habermas in this, but I'll try to keep this short and early morning appropriate. I'm going to talk about three things briefly. The promise of globalization from this perspective of these 18th century thinkers, how that promise has been betrayed and how we find ourselves in the current crisis, and then something about what the path forward might look like. I'm happy to send anybody the longer paper that goes into this more. The paper itself is the beginning of a larger project, which will take a while. Okay, so Adam Smith, I don't need to tell this group the significance of Adam Smith, but also how distorted and maligned he is and his reputation. And he's trotted out for a number of propositions that really have nothing to do with what he ever said. I would say he's more famous for what he didn't say than for what he actually did say. But it's the 300th, I think 300th anniversary of his birth. And so there's been a lot of interest in reconnecting with his work and rediscovering the actual Adam Smith, particularly the Adam Smith who was a moral philosopher who was interested in trade and not an economist per se. So not surprisingly, in The Wealth of Nations, he never actually uses the word capitalism anywhere in that book. And in fact, he doesn't stand for the virtue of selfishness, which is what he's often brought forward by. But in fact, what he's really interested in are markets. And he has a very strong view of the significance of markets to produce well-being for the society that follow a market path. It's related to his argument about specialization, that for specialization to work, you need a market. The larger the market, the more successful the specialization, the greater wealth it's created. And yes, markets do have a way of harnessing self-interest for the social good. But markets are not built by selfishness. For Adam Smith, for markets to function correctly, they require trust. So really what he's interested in is what are the essential conditions for there to be trust in markets and therefore for markets to function. And the second, well, there's two parts to the trust element that he's talking about. One is that you trust that people will keep their bargains. So there's a role for law and a role for fairness in this, a role for law. And the second is you trust that the market will be fair. And that's both about law and about justice. So really, Adam Smith is the opposite of the sort of laissez-faire distortion that we have of him. For Adam Smith, a free market is not a market that's free from law and regulation. It's a market in which the market itself is protected from the distortions that powerful actors try to introduce into the law and into market relations. So it's really quite a different picture when you look at it. All right, I'll come back to him in a little bit. So Kant, another thinker that I don't need to introduce in this group. I'm looking just at his Perpetual Peace, that wonderful little essay, 1795. Towards the end of the Second 100 Years' War, he has this crazy idea that actually now he can see a path forward for perpetual peace. So if you think about it, he's writing at a time of tremendous crisis for decades, generations, not too different from where we're sitting right now. And he says, oh, by the way, I actually see in the current situation a pathway forwards to perpetual peace. And I won't go into his whole argument, but the second argument is the one I'm interested in, which is what we can call the argument from commerce, which to summarize is that one of the three drivers that will bring us to perpetual peace is international trade. So sooner or later, countries are seized by a spirit of commerce, and the spirit of commerce makes it more difficult for them to go to war. So states, their merchants, and the bankers of the merchants have a vested interest in seeing that economic relations are not disrupted through conflict. So if you put these two together, you would think that globalization should be a high watermark for our society, because we have lots of trade, we have huge markets, lots of connections going on, and yet obviously we're not sitting in a time of peace or widespread prosperity. So what went wrong? Second part of the talk. This is where I turn to Habermas, because Habermas wrote about Kant's project at the end of the 20th century. And he was very interested in this problem because at the time, this writing in the 80s and 90s after World War II and everything, Habermas is saying it looks like from the surface that Kant could not have been more wrong about his predictions for perpetual peace. And yet, Habermas felt it was worth going deeper and looking at what exactly was Kant arguing Why has it seemed not to work? And can we say that it might actually work anyway? And so he takes a look at the second argument as well as the others, of course. And he agrees with Kant's basic intuition that connectedness should produce less conflict and more peace. And he says, yes, there is a way one can see that the growing interdependence of societies in the latter part of the 20th century could still create the preconditions for more peaceful relationships. But he says Kant was wrong about capitalism in a way that he couldn't help. That Kant could not have seen in the 18th century that sort of imperialistic and hegemonic and class struggle aspects of capitalism that was just not apparent yet to Kant at this point. So he said the problem with Kant's idea is that capitalism itself is undermining peaceful relations. And he looks at two aspects of capitalism, the tendency to resolve inner conflicts by projecting them outwards and demonizing others, and then trying to get into economic warfare and other kinds of warfare to try to create apparent successes to mask underlying class conflicts in capitalism. So he says capitalism is actually going to be constantly subverting and undermining the possibility for the peaceful relationship that otherwise might come through trade. So some of this might sound very familiar as we sort of come at the climax or the death knell of the neoliberal form of economic globalization. And that's really where I'm landing for the second part of this, which is that what Kant couldn't understand and what Adam Smith did not foresee exactly either was the particular form of capitalism that shaped globalization in the last few decades. And so if we look at the problem in the current architecture of globalization, it's not globalization per se, I would argue, but it's a particularly inflected form of globalization that I think many people would agree with. And that's not to say that Kant and Smith were wrong about what they thought about markets or what they thought about the potential of commerce to build orderly, peaceful social and economic relations, but that they did not understand a particular form of capitalism that was going to undermine everything that they were trying to argue to be possible. So what do we do about that? Well, I'm going to suggest three things. The first is that we reconnect to the basic progressive capacity of globalization, which is about connection. So it's all about connectedness. We've seen the financial crisis, the negative side of connectedness. COVID is both the negative and the positive side of connectedness. There are lots of examples of this when I go through this more in the book project. But the main point I want to make here is just because connection has been hijacked by certain economic actors, according to a certain economic ideology, doesn't mean that connection is wrong or that connection is inherently suspect. That's the regulatory challenge. How do we recapture the progressive possibilities of connectedness and strip it away from the way it's been distorted through economic power? So first is you reconnect with connection. And second, and this is related to the subject of our conference, is you have to go through and systematically strip away the neoliberal elements that have been built into international economic law and its institutions towards something else. And I've written in other places about what I think trade is actually about mutually beneficial consensual exchanges. It's not about extraction, it's not about coercion, it's not about exploitation. So we see a lot of exploitation and coercion and predatory behavior going around. It's not really trade, and it's certainly not what Kant was saying trade was, or the kind of trade Kant thought could build peaceful economic relations. So we go through the Bretton Woods institutions and international economic law and refocus it towards the kind of mutually beneficial reciprocal exchanges that Smith was talking about and that Kant was talking about. And then we see where that can get us. The third and the last point is, I think, in terms of being ambitious for our field and for our society, we want to be thinking about the global social contract. And Stiglitz has written a lot about this, and Stiglitz is no high-eyed idealist, but he thinks it's necessary, it's achievable. He sketches out a lot of good elements. There are other people talking about this. But I think that's really the vision that I would hope to come out of this crisis for international economic law, for our discipline, that we work with the political forces and economic forces to construct that kind of global social framework. I think we see interesting elements of this, and this is where I'll stop now, in things like the global minimum tax conversation, or the potential of financial transactions tax, or some of the work that's going on in deepening the decolonization aspect of international economic law. So I think that's really where we want to see coming out of this. It's not just about correcting the mistakes of neoliberalized globalization, but setting an agenda towards something like a global social contract. I'll end with 2 points he makes about this. One, he says that people who can affect each other ought to be subject to a shared constitution. So in a way, we're just going back to what he was saying several hundred years ago. It says, insofar as globalization is all about affecting one another, then we deeply need to have a shared constitutional framework within which to manage those interactions. Second thing he says, he talks about his argument from commerce, and he says this about it. He says, it's not such a logically powerful argument that I can say as a matter of theory that commerce will bring about peace. But he says it's likely enough that working towards it is meaningful. And I think that's as much of a motivation for me and I hope for all of us in this field.
Thank you so much, Frank. I just don't remember. I remember this could be just something I vaguely remember about Adam Smith, but there was always, he always said, so long as the goals of justice were maintained. There was some always parenthetical within his broader context. And he was, I think, working on something before he died. Is that right? Something.
Yes, he had a third volume he wanted to do about justice.
About justice. So it's really an incomplete, and it's something that I have always mentioned. So it's important that we know about Adam Smith and his work that was incomplete, left incomplete. Otherwise, you don't get the full story.
Yeah. And I'll just say his first book is all about empathy. And I think that's a miraculous thing. An 18th century economic thinker is writing a book about empathy.
Well, you're right, absolutely right. That's wonderful. Thank you. I think we are going to move, take a little shift and look at now China. We'll turn to this one.
I'm waiting for the slides. Let's see if it works. No. This is the wrong slide.
Is that correct?
Earlier, I think you need to
Go back.
Yeah.
There.
See if it works. Yes, it works. Okay, cool. So good morning, everyone. Thanks for having me here. All the more so as I'm not really a trade lawyer. I'm a technology regulator, a technology lawyer, and a specialist in Chinese law. So you might be wondering why I'm here. Well, which is, a very deep question. No, trade law matters a lot, of course, in terms of IP, particularly high stakes, technology intensive disputes. And when it comes to China, transparency requirements under the TRIPS agreement are of particular importance, as I will hopefully clarify through my talk. So I'm currently working at the Turing Institute, which is the National Institute of the UK for Data Science and AI. But this particular work was done mostly at Tsinghua University in Beijing, the University of Macau, and at this, Asia IP and Technology project at Berkeley Law, where you might know there is Mark Cohen, a wonderful specialist in this kind of transactions. So the background related to TRIPS is that Article 63 includes this transparency requirement according to which states must disclose final IP cases of general application, both judicial and administrative. This is a phrasing similar to disclosing laws, but it carries much more contention, as we will see. It was seen as a win for corporations in the sense that, of course, this requirement helps corporations with regulatory predictability, so for their investments and such. So a win for corporations over states, in the sense that states, of course, for states, it's a burden, and particularly for China, as we will see. So why does this provision matter? For corporation, again, as I said, for foreign direct investments and research and development, for states to establish channel of trust-grounded cooperation and dialogue, in the sense that it lowers, information asymmetries, for example, in negotiating agreements, to get a clearer enforcement picture, which in China is particularly important. One thing is to know the laws, one thing is to see how they're actually enforced, first by law enforcement, and then, applied by courts, to improve then the rule of law domestically in a sort of race to the top. If jurisdictions know each other, know how courts, each other's courts are behaving, they can strive for a sort of race to the top, to possibly harmonize and converge when it comes to substantive rules of intellectual property. Think about hidden or overt citation patterns, right? If you know the case law, you can hiddenly, like in China, or overtly, like in certain other jurisdictions, converge, hope that the law, converges across time. And then to check how domestic courts incorporate the principles of WTO itself. Now, I didn't read the most important one, which is, it's particularly important when it comes to the WTO dispute settlement situation, in the sense that when you sue a state before the WTO, you need to ground that lawsuit on something. And that something is also the case law of the country. So for China, it's particularly strategic, of course, to claim, well, I'm a civil law jurisdiction, so I don't need to disclose cases of general application, in the sense that, of course, if you don't do that, you don't supply the raw material for other states to sue you. And even if they do, they won't have such a strong case, as they could have had knowing your case law. Background on China then. It's systematizing its case law, officially in many categories, unofficially in countless databases, and even less officially through a lot of apps. This has accelerated with President Xi Jinping, of course, as a grip on courts. It's much more complex, but I need to simplify. Particularly in the IP realm, a bit less in other realms like criminal law, security. There is not very much disclosure, even less categorization. But we do have a lot of categories of IP-intensive cases in China. Some of those are categorized as guiding cases, typical cases, model cases, exemplary cases, and this matters a lot. Even if judges cannot cite those cases directly, it depends on the judges, the courts, etc. For example, specialized IP courts might do, but anyway, even if they can't, they can cite directly the judicial interpretations by the Supreme People's Court that is based on those guiding cases. So you see that it's slowly but certainly moving towards an hybrid system, which matters for the transparency requirement. And all these procedures are strengthened by the Supreme People's Court guiding opinions and implementing measures that clarify how these guiding cases, so how these categories of cases can be applied. You see that it's a sort of course, they are not going to be strictly binding, but they will absolutely substantially inform the outcome of the subsequent cases. This is all the more important as cases in general in China are very dry. If you have read any Chinese case, you might find yourself a bit displaced compared to Western standards because they were used to be quite dry, but they are no longer that much. And blind spots remain though. So even if we have these categories of cases, it's important to understand that a few blind spots will remain. And so we have to make sure that it's not political selection, the kind of cases that we are looking at. So what is the contention? Of course, the US and China submitted several communications, requests for disclosure to the WTO, requiring China to disclose all case law, which it's obviously not going to work. And so we have had this back and forth for more than 30 years between China and between the US and the EU on the one hand and China on the other hand. So China said, I'm not going to disclose that. That provision in the TRIPS agreement only applies to common law jurisdictions. I'm a civil law jurisdiction. How can I have cases of general applications, right? And also it's general application, not general applicability. So why should I disclose cases that obviously don't apply to all cases? Maybe they might apply, so it's applicability, but it's not application. And yeah, you can ask that, but I don't have the corresponding obligation to provide those cases. Anyway, your request is overbroad and administratively burdensome because I'm a developing country, so I'm not going, which is partly true, by the way. You have a coastal line, very developed, but courts in the inner China, it's another story. So this is partly true, okay? counter arguments by the US and the EU. Well, then why did you negotiate that provision in the first place, right? If you thought that it only applied to civil law countries. And then, well, basically you do apply those cases. This is the key point. You know, beyond the contention applicability, in the end, those guiding cases are shaping disputes and are shaping exactly the outcome of those disputes, high-stakes, technology-intensive disputes that are of particular interest to the US and the EU. For example, standard essential patents, which are, you know, the most valuable kind of disputes that you might have under the, you know, within the scope of the TRIPS agreement. Let's put it that way. And in the end, the US and the EU replied, yeah, of course, you know, it's administratively burdensome, but it's also time saving for the courts to disclose and for investors, because investors will, you know, catalyze their economic presence in the country. So from a appeal perspective, of course, this has been addressed for, again, 3 decades to no avail. You know, they argued pacta sunt servanda, good faith, of course, nothing worked. Ordinary meaning of the expression general application. Of course, nobody cares about the ordinary meaning, especially, you know, imagine the Chinese delegation caring about the ordinary meaning under the Oxford Dictionary. You know, they say, excuse me, but why do we care about the Oxford Dictionary? Especially if, you know, these provisions are also translated and retranslated and stuff. So, you know, ordinary meaning out of the question. Then we have this systemic integration, which does work. In many contentions of this kind, even before getting to the contention at the mediation level, it works, you know, the systemic integration, but it doesn't in this case, because you don't have expressions that are very, you know, that are really the same and that bind both parties under other treaties. So it's inapplicable. Travaux préparatoires, they don't help. There is even a lot of work on that shows how the TRIPS agreement was redacted many times, but in this particular case, it doesn't help understand why this provision was put there, even though civil law jurisdictions, in theory, they might have some residual claim that they don't have case of general application. China starts having now, and that's my point here, it's hybridizing, so it does now, but it would have made sense for China to submit these arguments 20 years ago, okay? And then they argued—
would not, would.
It would have not.
It would have not.
In the sense that, no, so it would have made sense 20 years ago in the sense that China was a typical civil law jurisdiction where cases had no binding effect on third parties. They didn't inform the outcome of those other cases either. So at the time it was negotiated, probably it would have made more sense to submit this kind of counterclaims to the US and to the EU. But today, because of these guiding cases, technology, particularly in the IP sector, we have a lot of these cases that are really strongly, binding is a weird word, but they're very informative. And they're incorporated within the judicial interpretations by the Supreme People's Court. So in any case, through them, they're going to be binding. So today, it makes no sense. But at the time of negotiation, it did kind of make sense. And then we have differential responsibilities. So China claiming, the usual arguments that, states from the global north should accommodate differential responsibilities for associated obligations for developing countries, particularly in this case about administrative burden. But yeah, so this is all the arguments that under public international law they never worked it today. So I move on with a teleological take, drawing indeed from this hybridization of civil law systems. So basically my claim is you haven't been able to solve this dispute in any of those ways under public international law. What should we do? Well, we should look at, what's the practice of civil law jurisdictions today. One thing is to say, well, the EU is also comprising mostly civil law jurisdictions. So, while the TRIPS agreement should be, understood as covering those jurisdictions as well. But most importantly, there is a trend in civil law jurisdictions to hybridizing. You can look at, I don't have the time to go through that, but really, if you look at East Asia, if you look at Southeast Asia, Indonesia, Thailand, the Philippines, if you in Europe, my country in Italy, the Corte di Cassazione, it's basically binding on lower courts more and more. And this is because the legislator has less and less time to cope with the pace of their regulatory demands. There is no time for the legislator to regulate everything that needs to be regulated. So because of time shrinking, all civil laws jurisdictions in a way or another are hybridizing. In Latin America, Brazil, Argentina, even Canada is hybridizing. Of course, it's common law, but it's hybridizing in the other sense, but it's much more complex. In any case, the point is, here is because of this hybridization, we have to rethink about the interpretation of this clause. And today, it might make sense for China to be bound to disclose certain cases that are indeed of general application. So again, my policy advice is to select according to a number of criteria, which I outline in my article. It's going to be published in, well, 5-6 weeks, let's see. But in any case, to outline, the point is to select some categories of cases that we might argue are of general application, are final, and de facto inform other jurisdictions about the regulatory environment and the enforcement landscape in China. Again, I don't have the time to explain how I identify those categories, but we might talk more about it later. This contention says a lot about times of crisis. Times of crisis, particularly with WTO, and with this, I will conclude. It's the last slide, I guess it's there. Yeah. So the crisis of dichotomies. Not only the developed versus developing that we also kept using, in this conference, and probably we should just stop using, but also the common law civil law divide. Under the TRIPS agreement, this is really fraught with controversies, and it doesn't help. So dichotomies, we should try as lawyers more and more to displace them from our writings and from the way we negotiate treaties. Second problem in times of crisis, obsolescent legislators cannot keep pace with the regulatory environment. So the demands of society, and they tend to outsource more and more segments of their lawmaking activity to courts, hybridizing civil law systems. Third time of crisis point, the unserviceability of traditional rules of interpretation in public international law. I have followed this, this contention to the highest detail. I have never seen anything around good faith, pacta sunt servanda, ordinary meaning, blah, 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 working ever. So probably we should kind of, problematize this in terms of TRIPS agreement and in terms of our relationship with China, particularly the way they understand lawmaking activities, the way they negotiate with third parties. And lastly, the untenability of the WTO as a high-level institutional forum for recomposing mistrust with China. If you want to understand China, you need to, again, probably displace the dichotomies and look at what courts are actually, what the trends are in courts today and what cases matter and inform, subsequent cases de facto, rather than speaking about, black letter law, which is of very little interest to them. Okay, this article will be published in this journal in 5-6 weeks. So if you are interested in knowing more, please check it out. It will be published open access. So I hope it will contribute to the debate. Thanks.
Thank you for your contribution. There are so many different issues, the civil law, the hybridization that's happening, and the technological pace that's changing things, the role of the legislature, and then of course the Chinese angle, and the fact that in certain areas it is working, but in other areas they're not disclosing. So it's all quite interesting. So we're going to now turn to Sylvia, right? Sylvia
Yes,
Chen.
absolutely.
We're going to talk about something with minerals.
Yes.
Another important issue for us.
So following from Frank's talking about connectedness of global commerce and how it's a drive, ideally, it could have been a factor driving force for perpetual peace. And now we are going to shifting paradigms of twin forces of geopolitical confrontation between US and China and geoeconomic fragmentation because of health crisis, economic crisis, actual armed conflict. And US went by, I'm looking at this, the IEL at the current state does not fit the modern commercial needs or policy goals. And I'm looking at from a US perspective of the critical mineral, securing critical minerals supply chains. Jake Sullivan, the National Security Advisor, pointed out that that U.S. is over relying, 100% depending on import dependent for 12 critical minerals on the U.S. Geological Survey's list, and on that hand, on the other hand, China controls 80% of the sourcing and also the production of these critical minerals. And that from the US perspective, over-reliance on foreign sources and adversarial nations for critical minerals poses economic risk as well as national security vulnerabilities. And yesterday, Victor talked a lot about the sourcing, what critical minerals are used for. Critical minerals are these, there's not a legal definition or scientific definition of why they are critical. These are a flexible list of what government considers what they need for economic needs and technological advancements. So US has their own list. EU has their own list. They're very similar, but with a slight difference. It depends on their needs. So that's one thing that I want to clarify. And so securing these supply chains is very important for our green transition as well as technological advancements. And I want to focus on the technological advancement part, where on the US and China competition. So recently we saw that China limits the gallium and germanium exports using export control means to impose this restriction. And so coming from the rare earth cases, the raw material cases, EU, Indonesia, nickel cases.
Maxi, deja jugar acá. Maxi.
Hello, Marjorie.
It was very strange.
All gonna leave right now.
They wanted to disrupt your thought.
Yes, yes. If a PRC knows.
It's a Chinese agent.
Oh, no, they really wanted to hear this. So coming from these case laws and the current development, we face crisis one is Article 6 opens up there, does not close all doors. Victor talked about this yesterday. And so there are other means to make critical minerals more expensive, less accessible to countries that would industrial production lines and supply chains. Crisis second is on subsidies. We know that China SOEs, through their Belt and Road initiatives, invest heavily on foreign mines and as well as downstream supply chains. And US at the same time is subsidizing local mining initiatives as well as working with partners through investment initiatives. And how do we rein in heavy subsidization through cross-border and the fact with public SOE public priority issues? And lastly, as the crisis number 3 is the national security, invoking national security exceptions in these critical mineral export restrictions. And an overarching case governance issues within all these crises is that enforceability issues. Indonesia appealed into the void. And how do we enforce these and resolve these conflicts? So my proposal to these issues can look through proposal 1 solution is regional trade agreements. The regional trade agreements leave out gaps of certain countries, resource-rich countries, for example, like Argentina, and their relations with producers does not really get covered in current large regional agreements. So we still have gaps for all these trade suppliers and suppliers that cannot connect with each other using the rule-based system. So my solution 2 is going back to what US and EU are trying to do is creating a partnership, the so-called the Critical Minerals Club. And that the danger is that we're shifting away from the multilateral rule-based system. But yesterday we heard from Meredith talking about omnilateralism and plurilateralism. That's really important to this aspect because when you want to fix a gap, it needs to be an IEL plus. And the Critical Minerals Club can be that source for IEL plus. So we're moving, and I recommend a hybrid system with the rules that existing rules plus a standard model, model-based standard model of governing these needs, and of course to be more specific to address needs and policy, commercial needs and policy goals that that we need both suppliers and producers of the critical mineral supply chain in the club. And that's what we cannot exclude China from this club. And currently the market really, most of the market wants to move towards a sustainable, responsible mineral source. And it helps with our developmental goals, not only on climate, but also on the ESG aspect, on the social responsibility aspect. And we cannot have a bifurcated supply chain in the global trading system by having China and their allies and their mines in artisanal and Chinese government SOE mines versus the Western Glencores or Albemarle mines that live up to standards that Western countries that want to impose. You cannot separate those two supply chains because it's really hard to enforce and monitor and a whole account of what the minerals are, what minerals are coming from. So, to achieve what we want, a responsible mineral, is that China needs to be in this critical minerals club and agreeing to the basic rules that we to continue diversifying the supply chains. Well, it's very ideal that whether China wants to give up their dominance in the supply chain or not, right? But on the other hand, like we can endeavor to try, right? So ask China to be part of this. And so that's my idealism I play, and I would love to hear your input.
Thank you, Sylvia. Important issue that we have done with these special minerals that we need so much for our industries. Tony, I think you're next.
Thank you, Padideh, and thank you to the hardworking organizers at SIEL, like Marcus and the others, for putting together this excellent conference. This morning, I want to talk about the American Inflation Reduction Act, or the IRA, and in particular, the subsidies that it provides to consumers in the US for their purchase of electric vehicles and other kinds of clean vehicles, which I'll refer to together as clean vehicles. As of course, all of you know, Professor Hillman addressed the IRA and these subsidies in yesterday's plenary on climate change. And it's an extremely daunting task for me to think about trying to figure out something that I can say to add to her excellent presentation yesterday, but I will endeavor to try, and I'll seek your indulgence in that regard. And I'm confident that many in the room will correct me if I get too far off the rails. One of the things that Professor Hillman said yesterday, and of course he's right about this, is that the IRA, including the clean vehicle subsidies, is a major shift, a major initiative from the US to address the climate crisis. But as Professor Hillman also said, the clean vehicle subsidies have a variety of other goals. They have economic security goals, industrial policy goals, national security goals, and goals related to its US strategic competition with China. So what I want to do today is talk a little bit more about the background of the clean vehicle subsidies, what those goals are, how the clean subsidies seek to achieve those goals, and then conclude with some comments about the implications. And as we'll see, I think it'll be obvious, it's obvious to everyone already, that one of the specific implications is a direct challenge to the kind of connectedness that Frank was talking about earlier. I want to begin by building in a very specific way on some of the things that Sylvia just talked about with respect to the role that critical minerals and batteries play in carbon transition in the specific context of the IRA, and how that context led to the clean vehicle tax credits that we see in the IRA and in the particular form in which they appear. So the basic proposition, as Sylvia has laid out, is that in order for the US to effectively work towards transition away from a carbon-based economy, they need reliable access to batteries and other technologies that are essential for that transition, and the critical minerals that are incorporated in those technologies. And the problem for the US in that regard is obviously that China is entirely dominant in the clean vehicle supply chains, the supply chains for batteries and for critical minerals. And on the other hand, the US and its allies, by contrast, have very little in the way of critical mineral deposits in the ground. They have very limited capacity to process, smelt, and refine critical minerals. They have limited capacity to produce batteries. The related problem is that the development of new mines and new processing facilities for critical minerals, as well as new battery production facilities, are extremely dirty as activities, and strict environmental legislation in developed countries make it quite complex and challenging and politically difficult to actually ramp up production in these areas in developed countries. So we're in this situation where we have this concentration of the clean vehicle supply chains in China, and that of course means that the supply of minerals and technology that are essential to carbon transition is at risk in relation to things that happen in China, including local events like the flooding that we've seen recently in China, but also, and perhaps more importantly, the intervention of the state. And Sylvia has mentioned this, the not infrequent strategy adopted by the Chinese government to restrict the export of critical minerals, and they've done this again most recently just last week. So Congress passed the IRA in part with the goal of reducing US dependence on China for components in the clean energy supply chain. How does it do that? Well, excuse me 1 minute here. The subsidies are only available, only available for vehicles that are assembled in North America. They're also only available in circumstances where the batteries meet certain content requirements, and the critical minerals in those batteries meet certain content requirements that favor the US, Canada, and Mexico, as well as, to a lesser extent, countries with which the United States has free trade agreements. Now, let me just remind you about the specific requirements of these subsidies. So it's a consumer tax credit of up to $7,500 available to purchasers of clean vehicles, but it's only available in connection with vehicles that are assembled in North America, where the critical minerals in the batteries in those vehicles are at least 40% extracted or processed in the US, or are recycled in the US, or in any other country in which the US with which the US has a free trade agreement. And that percentage is going up to 80% by 2027. In addition to that, there's a battery component requirement. 50% of battery components have to be produced or assembled in North America, and that percentage is going up to 100% by 2029. So the idea with these conditions is to encourage the shift in critical minerals extraction, processing, battery production, and clean vehicles away from China and to the US and countries some of the allies of the United States. So one of the goals is supply chain resilience. And this is a sort of valid environmental objective in the sense that the US wants to ensure that US industry will have access to the things that it needs to produce clean vehicles. And one of the ways to do that is to move supply chains out of their very strong reliance on China. But the clean vehicle subsidies are also seeking to achieve a variety of other policy objectives by reorganizing supply chains. So one is to enhance US economic competitiveness in clean vehicles and their components by attracting investment in clean vehicle manufacturing, battery production, and although this is, I think, a bit unlikely, critical minerals extraction and processing, and as a consequence, boosting jobs in the US. It's also intended to improve the US position in its geopolitical competition with China, and as well as has been indicated by Sylvia, to protect its national security. Now, when the IRA was first introduced, perhaps not surprisingly, it attracted very strong negative response from its major trading partners, including the EU, Japan, and China. One obvious concern was that clean vehicle subsidies would exclude vehicles that are produced in countries other than outside North America, and that would impair the competitive position of their exports to the United States, put them at a competitive disadvantage, reducing their exports, but also ultimately encourage investment in final assembly of vehicles in North America. And even if foreign automakers did transfer their final assembly to the US, they would likely still run into problems if they didn't meet the critical minerals minimum threshold requirements and the battery component minimum threshold requirements, likely because they were still relying on their established supply chains involving China. And of course, that would have an impact on their sales in the US, and again, would create incentives for investment to meet the requirements for the credits. And the way the incentives are structured in the IRA more generally, the main beneficiary is likely to be the United States in terms of all of these benefits, particularly foreign investment, because there are, in addition to the clean vehicle tax credits, there are additional subsidies for production of clean batteries and other clean technology in the US. So even Canada, which is a beneficiary of most of the preferences in the clean vehicle tax credits as a country in North America, was concerned that the combination of the credits with these other incentives would result in the US being the primary destination for investment stimulated by the IRA. So what happened as a consequence is that some countries, including Canada, very shortly after the IRA came into force in last summer, adopted massive subsidies programs of their own. And there's been a call in many countries, including in Europe, notably Emmanuel Macron of France has called for the adoption of a discriminatory Europe first policy to respond to the IRA. Now, as part of the response, US trading partners have characterized the clean vehicle tax credits as inconsistent with WTO rules. And we don't have time to get into that today, but it doesn't require a lot of thought to think about the challenges that these initiatives in the clean vehicle tax credits impose for MFN, national treatment, and provisions in the agreement on subsidies and countervailing measures, as perhaps trims and a variety of other WTO agreements. But I think suffice it to say that I think the argument's pretty strong that when you have very specific, origin-specific discriminatory provisions that condition the access to subsidies on where vehicles are assembled and where certain inputs originate, that sounds like discrimination contrary to the WTO rules. There has been no WTO claim commenced, although it's been advocated in a number of jurisdictions. And instead, what we've seen is a very significant flurry of negotiations between US trading partners, particularly Europe, Japan, and a few others, with the US to try to get the US to mitigate some of the discriminatory effects of the clean vehicle tax credits in the course of implementing the legislation. And there have been some modest changes in that regard, which were referenced by Professor Hillman yesterday. We can talk about them if you'd like. Just to sort of sum up, I think it's really a bit too early to conclude exactly how what the effects of the clean vehicle tax credits are going to be, how they're going to work, but there are at least a couple of, I think, reliable takeaways that we can identify at this stage. I mean, first, obviously the IRA represents a major environmental initiative for the US, a sharp break from previous practice, and in that sense, it's a very welcome initiative. Nevertheless, it's the positive environmental effects that are likely to flow from that initiative have nothing to do with the discriminatory features of the clean vehicle tax credits. And in fact, if you eliminated the discriminatory features of the tax credits, you'd undoubtedly facilitate the transition to clean vehicles in the US much more effectively. There'll simply be many more clean vehicles available on the market for purchase. By one estimate, 70% of the electric vehicle models which are currently on the market in the US are not eligible for the subsidies and are not likely to be for the foreseeable future because there are of the difficulties in adjusting supply chains to get access to scarce critical minerals and battery components and so on. Now, as I mentioned, the discriminatory design of the clean vehicle tax credits, and the consequent attempt to sort of shift the structure of supply chains does have a conceivable environmental justification. It's designed to secure access for US industries to the things it needs to produce clean vehicles. But the shift in supply chain, as I've discussed, has these other objectives as well. The objectives related to advancing US geopolitical aims, advancing economic security, economic growth, US jobs, and national security. The second thing I guess we can say, and this is certainly not an original observation for me, is that in terms of the international trading system, the overtly discriminatory character of the clean vehicle tax credits is really a strong confirmation, further confirmation of the US drift away from respect for the WTO rules and towards a discriminatory America First industrial policy. A number of other people have made that point at the conference already. As far as I'm aware, this is the first case in which the US has actually made subsidies, certainly consumer subsidies, contingent on local content requirements. So in that sense, it's a kind of a milestone in the movement away from WTO-based commitment to the WTO system. And I think more generally, the clean vehicle tax credits are kind of a concrete example of the dominant role in current US policy of considerations related to security, including economic security and geopolitics, over traditional trade priorities. And the recent speeches by the USTR and various other government officials have simply confirmed this kind of reshaping of US policy. And so as such, I think it's quite obvious that the clean vehicle tax credits and the IRA more generally is a direct challenge to the multilateral rules-based system and further undermines respect for the WTO. I think it also, we've seen some of this reaction already, it encourages other states to defend their economic interests more generally when the US has taken the position that the shared economic interests globally are simply not a concern anymore. And as our panel chair has said, free trade is a bad word in the US. Now, of course, the threat to the US is going to be exacerbated to the extent that other countries engage in discriminatory, non-WTO compliant retaliation in response to clean vehicle subsidies. So there's many other things that one could say, but let me move it down.
Thank you so much. Thank you. Let's go to Rodrigo, and then we come back to have a conversation about all of this.
Thank you very much. Thank you very much.
Maybe we have a positive note.
Yeah. I think because I organize this, and I'm a positive person. You know me, if you know I'm a positive person. So I'm happy to move away from the doom and gloom a little bit. So we have globalization hijacked by neoliberalism. We have China and the Western powers fighting about critical raw materials and IP. We have the US going full protectionism without any shame or remorse at all. So in the middle of all of this, you have multilateral institutions, they don't work. International trade law is in crisis. International investment law is in crisis. Economic nationalism is on the rise. And in the middle of all of that, there is kind of a ray of light. It reminds me a little bit, if you like old music like me, 1974 Super Trump crisis. What crisis album that is just there? To move away from reggaeton and trap music. because it's nothing short of a miracle, in fact, that in this context, a group of like-minded countries at the WTO premises, even some members don't like that part, agreed on an investment facilitation agreement. So it's both an exception from the point of view of the crisis of the trade system of WTO and on investments. My point here is not to tell you that this is a miracle and some miracles are perfect and there's nothing to judge about this, but to tell you a little bit what are I would say the good elements of this agreement and maybe inform some positive developments for the future. So why this agreement is so important, as I mentioned, not only because it's a reaction, a positive reaction to this crisis, is because in a way, investment for trade, it was a little bit la bête noire. It's a black beast. Since you read the Amana Charter, it was there, and then it was not there. They look around, and then they keep it out in Cancun. And we have treaties, yes, but it's fairly limited. And so it's the first time we have investment inside the WTO proper. For the point of view of investment agreements, we do have a lot of investment treaties, but most of them are bilateral. What we have multilaterally, we have some, but mostly about procedural stuff, about arbitration, about insurance. So here we have about the substance, but not the substance we are used to. So some other substance. I will go to see that. So this is a little chronology. I won't repeat myself, but it's kind of surprising in a very short period of time for WTO negotiations, I would say. Countries agreed on this text. They started with a group of like-minded countries. This is, you know, what's happening with the GSIs now. And little by little, they started advancing the text, different texts, the Easter text, and finally, just a short of 1 week ago, it was publicly announced this treaty. What is telling is not much of what is in it, but of what is not in it, and who is on board, but most importantly, who's not on board. So a large number of countries are part of this agreement, and one more than the 2/3 of the constituency of WTO, which is relevant for other purposes. But who is not there? The US is kind of a little bit important, but the US is not there, not in a passive-aggressive attitude. It's not there, but it's not against it, seemingly. Because there are the two countries that are basically not there and they're pretty much against it. And these countries have been pretty much against that many things in recent years. It's no surprise that it's India and South Africa. But what we talk about when we talk about investment facilitation? Investment facilitation is a very fuzzy concept, and the lines between facilitating, promoting, or doing other stuff that is related are not very clear. The OECD, the World Bank, the G20, they don't even agree on a common definition. But you have some elements. Basically, you want to make investment easier, to speed up investment in a country. That, as we all know, we need investment to achieve sustainable development goals. So it should be a good idea. I mean, countries, they should rule for this. But the problem is that we are not regulating about investment facilitation in a point. We are regulating investment facilitation in this crisis, where everybody mistrusts everyone, and particularly investment. So probably some people would be tempted to say, oh, WTO is inventing investment facilitation. You know, some countries tend to do that, they have the gold standard, stuff like that. But this is not the case. Actually, this is a case, and I think it's very important for the evolution of maybe of WTO law, where you really see for the first time preferential trade agreements or bilateral investment treaties informing treaty making at the WTO. Trade facilitation agreement is true, is there, but trade facilitation agreement is very, very close to what WTO normally does. This is not the case. So if you look the history, and you will see that there are a number of investment facilitation provisions from way before, actually from 1996 onwards, you find treaties with these provisions. And you have certain main drivers. First, you find some investment facilitation provisions in China agreements and Chinese agreements, I'm sorry. Then you move to Brazil, is the main driver in the last decade. And recently, the EU negotiated with Angola, November 2022, with the very first EU investment facilitation. So if you look at the numbers, I don't want to bore you with this, but you go to shameless plug to the EDIT database, that is very good. You can check online, so you can find and track investment facilitation provisions, and you will see that there are many, not so many, but they are. And what you have there, if you categorize all these provisions, it's very difficult to read probably, yes, but you have like a menu of around 12 different types of investment facilitation provisions. And so these provisions are in international investment agreements, meaning bilateral investment treaties or free trade agreements with investment chapters. So what the WTO achieved with investment facilitation agreement? Basically, they took many of these provisions, and this is one of the other important elements. They put them together in a systematic package. Because I can tell you, yes, there is no innovation that they created many new provisions. But what is innovative is that they put all these provisions together. You don't find other treaty where all these 12 things are together. Okay, so what do you have in the investment facilitation agreement? This is what the WTO is making available online. You will see that there are some central tenets, and I would say the most important elements of the whole agreement are three elements: transparency, streamlining investment procedures, and special and differential treatment. The most important one is by far transparency, which is kind of ironic because the negotiation of the agreement has been everything but transparent. But it's kind of funny. You defend that principle, but you don't apply it much. It's the way it is. So people, they say, well, you cannot negotiate if you do not, you need to keep something. But this agreement, I mean, could have been more transparent in my humble. So what you have there from the menu we saw before, you have a lot of this. This is going to be published by the end of the year. You can read it, or you can send you the paper if you want to read more detail, but we don't have much time. But many of these provisions that I retract, that I mentioned before, that were present on investment treaties, they are in this. So again, the important thing is not what is in it, it's what is not there. And so, as I mentioned before, the novelty of the agreement is more than the provisions that are creating new provisions. Is they put them all together in a context of crisis with nobody trusts anybody, maybe few people trust few people still, and they put one element more very important. I would say the most novel element, in my view, they really get the special and differential treatment to another level, taking the example of the trade facilitation agreement, and they make this capacity building very, very important with this idea of the self-assessment guide, and develop a tool for developing countries to try to self-assess what they need to do to implement this agreement. But there are things that are not there, and you wonder, like, maybe there was kind of a ranking, what should be included and didn't make it to the cut. So you don't have information about facilitation of investment permits. You don't have provisions on the improvement of investment climate. You don't have provisions about investment financing. You don't have provisions about investment insurance. And the one I regret the most is that in previous drafts that I'm not supposed to know them because they were leaked, but I read them anyway. I won't say who gave them to me, but they were there. There were provisions on home state obligations concerning investment facilitation. And I think they were very well placed. In the final text, seemingly they're no longer there. And this is really a pity, I think. We can develop that on the Q&A if you want. So in conclusion, it's not everything is doom and gloom. We can, in the worst scenario, we can make something out of it. I think the investment facilitation agreement is a good moral story about like-minded countries bringing together a controversial topic inside of WTO with rules that, in my view, they represent development of investment treaties already long ago. It's not perfect. Gabriel Marceau just, I think, left because she's the one who will answer you all the questions about how we can plug this with the WTO, if we can. I'm not sure of that. And the other elephant in the room, the whole treaty tried to insulate itself from ISDS. I know it's very controversial, we can discuss it. I think that there is a tiny little possibility that any way you can bring a claim. I'm not sure if you're gonna win at that claim, but there is a tiny little bit. But I think the risk is worthwhile. If we really are serious about getting more investment to obtain the sustainable development goals, we should run this. So that's it.
Thank you. Thank you on that positive note. One thing that you did mention about the process not being transparent, and I've always said that transparency is actually an opaque term, and that's the paradox of it. The Obama administration was very non-transparent in the way they were negotiating the TPP. If you were in Washington, it was almost impossible to get a draft of the TPP. I mean, there were certain leaks, the IP provisions were, and I think the justification for that was, we don't want the thing to die before it happens. It might have been the same kind of justification. When it's interesting, when you want to make things happen, it's sort of the democratic participatory aspect sort of goes to the side. It has to be a small group. It has to be like-minded group. It has to be kept confidential so that it can get to an end. So what are we sacrificing in that process? But that all goes back to the fact that we don't trust each other. There is no trust, and there is no, the big picture. There is no empathy, which is what I think we started with Frank. I mean, we have lost what this cooperation was supposed to be about from the very beginning. The big picture is we are on the wrong track. So whatever we do is going to be incremental and it's going to come out wrong, I think, in the end. And I think that's what we have seen. And that's where I think, Frank, you started saying that we went on the wrong track, and it's very hard to clean it up without fundamentally changing the way we think about cooperation. So I wanted to know if any of the panelists want to say something about what they heard after they made their presentations about others. Would you like to say something?
Maybe just a very brief point, also about empathy and the fact of trusting each other. So what I try to do with my paper is really to undo the China specialty here. I think we should kind of avoid to get into these confrontations bilaterally, like this is a problem of China, because singling out jurisdictions will place them very far away in the table. And China is big enough today to stop caring. So we have to make sure that this doesn't happen. So how do we do that? How did I try to kind of contribute to this?
That's a very important point, that they will stop caring.
Exactly, no, but they will very soon if we don't try to reconcile and to undo their negative specialty or their specialty generally. How? For example, in this case, I wouldn't want this debate to be about the position of China on civil law jurisdictions. The point is, I try to frame it as comparative law rather than as public international law, not only because public international law has just not worked, but because if you frame it in terms of a trend that covers many jurisdictions and it's about hybridization, and we can agree on something teleologically, saying, well, okay, you can't disclose everything, and we should actually stop expecting China to disclose everything. It's just simple. I mean, we're talking about hundreds of thousands of cases annually. It's just not possible. But we can say, well, there is a trend. It's a hybridization of civil law jurisdictions. And it does mean that you have a few categories of cases that are becoming de facto binding. So can we get down to this, rather than getting back to the TRIPS agreement, starting arguing what is, traditional, general meaning under the TRIPS agreement, mentioning the Oxford Dictionary, which was done during the negotiations with China. I don't think it helps, honestly. So again, undoing probably the China specialty will help fostering empathy and hopefully, bridging some divides.
Anyone else? Yeah, Sylvia.
So I wanted to differentiate my the critical minerals usage in green in the battery case and with the technological chips in the cell phones. So the reason why there is no the aspect of critical mineral supply chains and the US strategies has not extended, the local content requirement has not extended to critical minerals in these advanced technologies yet. But we can see that happening because from the example of the battery supply chain. So that's going to come. And another myth I want to bust is that I kind of push myself into that myth myself as well, is that China versus the rest of the world. China makes produce dirty minerals versus and the West is striving for what the US says. Let me quote from the White House, that focus on boosting strong labor, environmental justice, environment. There's a typo here at the White House press release. Environmental justice, community engagement, and tribal consultation standards. But think back in the last 20 years of human rights violations in extractive sectors in Africa. They were not as a result of Chinese investments, not so much, but I mean, Western companies play big roles. And then we need to think about how IEL plus all the other international legal instruments as well as disciplines into ensuring this goals of having environmental human rights justice and labor standards that not only governs the newcomers as China and also existing power players like the Canadian, Australian, South African mining giants.
You're sort of running out of time. Did you want to say something to me?
No, I think we should.
I think we should
get to the
open
room.
up
Yeah.
questions. Just raise your hand. Comments.
Thank you very much for these contributions. It's going to
Need the microphone.
with the microphone.
It's small, it's round.
Yeah.
Thank you very much for these interesting contributions. I'd like to raise two issues. The first one relates to the TRIPS agreement in your paper, and the second one to Tony's comments on the IRA. In the TRIPS negotiations, we clearly had a convergence that the leading cases should be published. Not every case, but the leading cases. And the main evidence for the convergence can be seen in the provisions on enforcement, where you can see an approachment of common law and civil law procedures in civil law and administrative law here. The point I, however, want to make is you say that the WTO is not suitable to decide this question. And I would oppose to that view because I gather that there are different views in China on this. Maybe the Supreme Court doesn't want to publish, maybe the government wants to publish. And so I think the Chinese government may be interested to have an arbitrator on this question. And this is a very normal case. Today, actually, the ICJ comes down with a maritime boundary dispute. And if you look at maritime boundary disputes, going back to the North Sea Continental Shelf case, the political economy of these cases is, which is the vast majority of cases in international law before the ICJ, is that both governments have an interest to have a third party making a politically difficult decision here. And this is exactly the same with WTO. And I think for that reason, there is a common interest because the countries are not like-minded to bring the case. So I think the WTO is perfectly suitable to address that question. It may take into account digitization, which wasn't there in 1990 when we negotiated this. And it may also take into account that China was not part of the negotiation at the time. But we will have to look at that. And if I may just put my second question to Tony, wouldn't there be other options to achieve these goals of gradually increasing the amount of US batteries or North American batteries in the car production as you go along? Then you could actually stimulate North American mining And you can also take care of the problem that 70% of the cars are not covered today. But wouldn't there be non-discriminatory ways to achieve these goals? Thank you.
Is that me? To Frank, I don't have a question to you. Just want to say that it was gratifying to hear from you on these historic sources and what they still mean to us today. Riccardo, I find extremely convincing what Thomas just said. Obviously, this text was written for the world, or at least the 123 countries which were part of that negotiation at the time. And amongst those were very many common law countries and very many non-common law countries. So, you know, the obligation was meant. And so for everyone, and the leading case concept convinces me immediately. I'm not an expert at all in this area, and so I don't want to say anything also about what you said. But I want to object to your concept and term of hybridization. Also not knowing enough about Italian law, but I suspect that this is not a good term to use, prone to misunderstanding, and we should stick to the basics of the legal systems that we have. There have been enough and too many misunderstandings on that. This has been extremely harmful in the WTO. We know where we have ended so far, and this has played an important role. Of course, we all know the role which jurisprudence plays and higher tribunals in every judicial system. But frankly, I don't understand why you use that term hybridization for things which in all these judicial systems existed for many decades, and where the structures and concepts are still in place, completely intact. The appellate body crisis, the role of precedent there, and so on, has led me to conduct interviews more recently with national judges, whom I know from long ago. This is extremely instructive because it shows you how things work and how they are perceived and how they work very well. And there is absolutely no binding force of higher tribunal rulings except in the case at hand. But of course, the jurisprudence plays a role, and that's what you mean, right? And that's the leading case of Thomas, but it's not hybridization. Thank you.
But I will get one question here.
First you.
Thank you. So my question is related to the broader theme regarding geopolitical confrontation and fragmentation. So US has clearly spelled out its geostrategic interest in the Indo-Pacific region. So this has ramifications as far as realignment of supply chains is concerned. So if this becomes a zero-sum game, which I mean to say if it's China's loss, somebody's gain, which countries like India, Philippines, Vietnam have. So it would have impact on the security situation in the Southeast Asia as well, which we see recently. So there is a risk of trade becoming closely entangled with security interests. So in that sense, how do you see the role of international trade in times to come? Can it play a positive role, or we see just it becoming a tool? As for the geo, no, that's it.
Should we, well, let's answer those questions. When we come to you, you can send it up here. And then we want to press all the.
Okay, 1 minute.
Okay.
Yeah, there might be a further conversation about this.
On the first point, I perfectly agree with you in the sense that that was the case. That was the intention of the parties. Not all parties today agree that that was, but I agree it was. The problem is that if you look at the communications by the US and the EU, what they claim is that China should disclose all cases. China did reply, no, if I ever disclose something, that will not be all cases. It's ridiculous. I'm going to disclose a few categories of cases. And guess what the US and the EU replied? No, your obligation is to disclose all cases. So what you say is true with regards to the negotiations, but the position, official position, reiterated through 3 decades of communications at trips, including Switzerland, which joined later, is on disclosing all cases. And this is why the contention has fired up a bit. On the points on hybridization, I respectfully disagree. I couldn't disagree more. Both on what happens in jurisdictions, domestic judges, it depends on who the one interviews, but trends are very clear. And in China, which is the point of my paper, they are extremely loud, these trends. There is an hybridization process that is regional, arguably global, but definitely regional. And it's aided by a number of factors, including the fact that today you can discover cases very easily. You can cite the cases very easily. You can compare, you can search. This is done through the internet, through AI. It will be done through ChatGPT. So it's a matter also of technology, it's a matter of data science as well. But there is a trend that is very clear. Now we can disagree on the term, of course, and we can disagree on the extent of this trend as well. But I think we should not disagree too much on the fact that there is a trend, and that it is particularly strong in China and meaningful because China is so powerful today. So we can't dismiss, what happens in China is one of the jurisdictions. It's as important as the US and the EU today. And hybridization, again, thinking about civilians, and if you look at literature, most of scholars say that most systems today are already mixed. I just add a little grain on top of it. And in any case, I agree that civil law and common law, as a terminology, helps us feel very grounded. We lawyers tend to love black letter law because, we swim on it and we feel very safe. But reality is much more complex. And when it comes to China, when it comes to negotiating and get our points across with Chinese negotiators, we can't stick to this dichotomy, in my view.
Chen, you want to briefly?
Just very briefly in response to Thomas, yes, of course, there are non-discriminatory ways in which a switch to clean vehicles could be encouraged. Lots of jurisdictions, including the EU, have substantial consumer subsidies that are for the purchase of clean vehicles, which are not discriminatory in terms of the origin of the vehicles. So that, in a narrow sense, is absolutely contemplated, something one could contemplate. It's also possible to contemplate non-discriminatory production subsidies. We have them in Canada, they exist in Germany and various other jurisdictions, in part in response to what was happened in the IRA. So I guess the only other thing I would say is it strikes me that one of the challenges here is, first of all, global shortage of the kinds of things that are needed to facilitate the transition using this particular technological approach. And one of the key things, it seems to me, is that, and the sum of this in the IRA, we need subsidies for investment in innovation in technologies that are cleaner, that don't involve hard to get critical minerals in the same way, that focus on recycling. And that's part of what we need to be doing going forward.
You had a question. And before we answer your question, why don't you verbalize it? Because we already run out of time. Oh, sorry.
Very short. First of all, to Rodrigo, what are those home state obligations that you were talking about? I would like to, I don't know if you can enumerate a couple of them. That would be interesting to know. I haven't read the text of the facilitation agreement in its current form. I don't think many people has, I suppose. But I have read the EU-Angola facilitation agreement, and there is, and I don't know the parallels, but there's this scope paragraph that says, this agreement does not create or modify commitments relating to liberalization of investments, nor does it create or modify rules on the protection of established investors in the territories of the parties or of their investors or on investor state dispute settlement. So what's the point of this agreement? Thank you.
Don't make the good, the positive go down. There's one final.
Yes. Thank you very much.
Yes.
Very quick question to Rodrigo. So I like your presentation highlighted the potential of the structured dialogue, joint statement initiatives in building consensus among a number of WTO members in times of crisis, and how the trade facilitation agreement shows that this can be successful. But if I understood correctly, I think that one of the preconditions for that success is that that process was building on existing laws in bilateral investment treaties rather than creating new rules. And if that's correct, that these mechanisms are successful when they are building on pre-existing law, does it mean we have no hope for other similar structured dialogues going on in the WTO, such as fossil fuel subsidy reform or plastic trades, where those pre-existing norms somewhere else are not there?
Thank you for that. I think you ran out of time, but I want to address the question I was asking back. I think Frank maybe wants, and anybody else wants to address about the broader theme of what trade is doing with regards to the potential tensions that are building up in the world.
Sure, maybe
Yes.
we could all take a moment.
Yes,
to
if you can
respond.
all talk about that.
Thank you for the question from the back. I would just say that I think that's the key role is for the legal imagination there. Because I think the role of trade is going to be what we make it. And that sounds simple, but it's not easy. So I think if we can identify incentives and patterns that countries and their leaders feel are worth not jeopardizing, then trade can play a more constructive role. And we can identify them, and the political will may still not be there, but that's not ultimately our responsibility. But I think we lose an opportunity if we don't try to use the legal imagination to identify those incentives and arguments and strategies that might reach across those tensions.
Anybody else want to address that?
I mean, I couldn't agree more on the sense of legal imagination and in the sense of, again, empathy. I'm going to repeat myself. The key point here is avoiding singling out jurisdictions and finding legal arguments or legal policy arguments to avoid this singling out to happen. And one of the ways to do that, again, we might disagree, traditional scholars and practitioners of the old times might disagree with this, but in today's times, which are so fast, so technologically advanced and so hybrid mixed, whatever you want to call them, looking at trends is going to help much more than mentioning the Oxford Dictionary, I suppose.
We're already way past time, so maybe you really want to say something?
Yes, I do want to address that your comment on Indo-Pacific regions and the framework and its geopolitical implications. And when you look at Taiwan, and also the neighboring countries, and they play an important role, not only economically in terms of chip productions, but also they're sitting in the defense line of the South China Sea. And so trade is one of many items that let's say the United States have in this toolbox to address the Indo-Pacific security issues. But on the other hand, trade, using the trade as a tool needs to go by a rule, go by its rules. So this comes in a conflict where you want to address security and political goals, whereas IEL is constraining its objectives.
Yeah. So we have like 5 minutes before the next plenary. I don't know if you want to talk separately.
You said yes, you're right. The only hope I see for future developments is for the e-commerce, because there is previous thing. And for me, the EU Angola is a downgrade from the Cotonou agreement. We can talk about it why.
Yes.
Thank you all.